You probably know me. I'm Shanna Welsh-Levin with SoCal Realty Law. At SoCal Realty Law, we help real estate investors protect the value of their investments. And we do that by removing unwanted tenants, providing solid contracts for successful transactions, and pursuing justice for property owners who have been harmed by others. Today, I want you to listen and absorb as much information as you can, but please understand that this isn't considered legal advice on any specific matter. When we do these special question and answer formats, I know it's hard to keep things general, and I'm going to try as much as I can, but we just want to make sure that everybody understands that I'm going to try to answer your questions, but also make the answers apply generally across the board. And if you have a specific situation that you do want to ask me about or ask any of our other staff about, then we can set up a 15-minute call or a legal strategy session, and we'll be happy to do that. And I might suggest that if your question gets a little too specific, I might suggest that we talk outside of the webinar. So I'm suggesting that you put questions in the chat. I'm going to introduce Jim and Lisa here and let them talk a little bit, and I'm going to ask them some questions. And while I'm doing that, if you brought your questions, please put them in the chat. I've made the chat private so that only the host and co-host will see it. And then the other option is that when I open the floor for Q&A, you could unmute or raise your hand. Actually, I think raising hands would be best, and then I can call on those who have their hands raised. And if there aren't questions, then I have, my usual PowerPoint and a few hot topics prepared for you. All right, so I want to introduce Jim Delaney and Lisa Manriquez. These two individuals are the main partner, the main people who are handling our unlawful detainer cases, our landlord services, and they handle about 70 or 80 cases. So we've got a high volume of these eviction cases, and those cases are at various different parts of the process, from issuing notices and just consulting on how we might remove a tenant to filing the lawsuit to going to trial. Jim's had a trial a week in the last 2 or 3 weeks, and so he stays really busy. First, I will talk to Lisa. Hey, Lisa. Hey, welcome, Lisa. So, what's your position in the unlawful detainer department?
So I'm the paralegal that assists Jim and takes care of all of you. And basically I'm your first point of contact. So if you need to reach out quickly, or, sometimes the question's more procedural and not legal advice, then I'm your person that you could reach out to help you know what we're doing next.
So you do our initial intake call. What's that all about?
So the initial intake call is after the client has signed a retainer, and Jessica, our intake specialist, sets up a 30-minute call with me. And basically that is to get to know me, for me to get to know you. I'm going to confirm all the information you may have already sent us, make sure everything is perfect. And then I'm going to ask you a few more questions about the tenants. I'm going to look at any of the documents that you sent. Most importantly, I'm going to explain the procedure moving forward, what the next steps are. And then at the end of the call, set you up an additional call with Jim, where you can strategize with him to figure out what you're going to do next, what notice you might be serving, and any legal questions at that time, you could talk with him.
Lisa is a real guru at handling all of the forms. All of our eviction cases are very form-driven, checking boxes and filling things in and making sure names are spelled the same way on every single form. That is one of her skills, is keeping all of that organized. She is also a guru of electronic filing, and special skill here is talking to court clerks, who are oftentimes not the friendliest, and Lisa knows how to get the information that we need. So Lisa, what are some of the most common questions that people ask you about the unlawful detainer process?
A lot of times it's what's it going to cost or how long is it going to take? Do I have to go to court? What I first like to offer them is Shannon created a great video that explains the procedure, what the next steps are. That's a great overview. And just to save you some time and money of not having to have a long conversation about it. Then once you've watched the video, then definitely I encourage people to reach out if they have any specifics. Um, I try to get it narrowed down to one step at a time rather than looking at this long, big picture of months, um, because the process can go in different directions each way. If they move out within a notice, if they don't and we have to go to a lawsuit, if they answer the lawsuit, if they don't answer the lawsuit. So it can go various ways. So generally, if they don't move out, then once the lawsuit starts, we'll generally talk every week because every week there's going to be something moving along. Um, I try to email everyone with the updates and what I'm doing next, just so you'll know. But those are usually the most popular questions.
You also work really closely with our process server to get the lawsuits personally served on the tenants. Um, what's the first one that comes to mind about the most interesting serve that you've had to work with our process server to do?
Well, he's great. We like to use him specifically if we can because he's a retired cop and also a PI. He's not scared. We've had cases of tenants coming out with weapons or running from him, dodging service. He's very, competent. He knows what service is and what it isn't, what he has to follow. They can slow things down, but we will eventually get it done. There's no way to hide completely. If we have to get a court order to post, we can, but he's really good. He's really quick. Um, and I can get him to do things in the evenings, at nights, on the weekends. So it's a great relationship. I don't just put something in the computer. I always follow up with a text. This is what I'm giving you. Let me know if you have any questions, any specifics we like to get from the clients. Sometimes it's hard to get to a door or they need it to go to a certain area. So we like that extra relationship with him so that way we can give him so many specifics.
And we're talking about Mike Madrano, who is a process server who we've used for many years. We've known him for a long time, and he's the best process server that we've found. We've worked with many, but Mike is extremely reliable. I was remembering when somebody tried to hit him with a car when he was trying to
Oh,
serve.
yeah. Yeah. So we've had a gun, we've had a car. That was actually a maid that was trying to run him over with the car. Yeah. So there have been some things, but he's not scared, so he knows what his rights are, and he'll get it done for you. So he's great. He's also a witness for us if we need to go to trial. The process server has to appear as a witness of who served the notice. And so that's why we highly recommend our clients not serve them themselves, to let us do it, because he's very well versed. Jim's worked with him a lot and it makes an easier witness and it's less stress on the client.
So another big job that Lisa takes care of is making sure that all of our witnesses are lined up and prepared to appear at trial, properly subpoenaed, properly informed about where to go. And Lisa, you always do an excellent job. Thank you so much. I really appreciate you
Me
being with
too.
us today. Now I want to talk to Jim Delaney. Jim is an attorney with SoCal Realty Law, and he has been handling the eviction cases. He runs the eviction department, the unlawful detainer department, and has been doing an excellent job of handling a pretty high volume of cases. So Jim, let's see, what are the most common questions that you hear from landlords who haven't been through the eviction process before?
Well, it's definitely a nuanced area because there are many ways that the outcome can transpire. A lot of times it's really, how quickly can I get them out? That's really the common question. And it's never a simple answer usually because the tenant's behavior and how they react will dictate the next steps in the process. And it's hard to digest that information sometimes, understanding that you might not have full control of the situation until you start issuing the proper legal notices. And half the time, it might take longer than you might desire. It's a game of patience as well as it can be frustrating times. So the outcome of what happens next, half the time it rests on the tenant and how they react to however we contact them and whether or not they're willing to talk to us or not.
Jim, you have to have amazing attention to detail to make sure that everything is lined up just right, because one defect in the case can cause the whole case to fail. So during the past year of handling these cases, what surprised you the most about the eviction process in California?
I would say that most surprising would probably be the length of time it might actually take for your local law enforcement to go out and perform the actual eviction that you hear about or think about on TV. It's a lengthy process, and unfortunately, if your lease isn't compliant when you come to our office, the first thing we're going to do is recommend you be compliant, just in case that becomes a defense that's raised in a lawsuit, which can again drag us on longer before you even get to court. And it's to no fault of the landlords. The laws have changed consistently over the last 2, 3, 4 years to the point where if you don't have a lease that was reviewed within a few months, there's a chance, depending on where your property is located, the law might have actually changed. Imperial Beach just had a new set of laws go in effect as of early this year. So, depending on where your property's at, if your lease is written on a napkin with only sentences, it's probably not compliant. So, there's definitely some things that we can't change before you come to our office. So that might delay the process longer than you would like. But we do it so that when we do go to court, the likelihood of success is much, much higher.
About how many landlords, percentage wise, are in compliance when they walk in our door?
10% maybe.
What did you say? You're breaking up a little
10
bit.
maybe 10%, and that
Yeah.
we maybe had them as a prior client. I would say 8 or 9 out of 10 landlords do not have a compliant lease.
Yeah, I agree with that. So that's the first thing that we try to assess. And one of the important questions is, where is the property located? Because it can vary so much depending on what city the property's in, what county the property's in. All right, here's another one for you, Jim. What if the tenant goes to jail?
Well, you can have a fun story to tell. Depends on why they're in jail. Um, if they're in jail, though, and they haven't forfeited their possession of the property, you still need to go through the proper legal channels to evict them. So the irony is they might actually have a different place to reside for an indefinite amount of time, but until you've completely had a surrendered lease agreement at one point, we would at least advise you to continue through with the eviction process. Even though they might not be living there, they still might have their stuff there. They still might desire to live there, so there's still a chance that they're a tenant.
You just finished a really interesting eviction. In fact, I guess it's not completely done yet, but there was the case where the landlord died and left a number of tenants for the administrator or the executor of the estate to take care of. That's an interesting one. How did you manage with that one?
Um, some patience, I suppose, was probably first and foremost because the the client inherited a pile of just a mess, really, and he had to deal with these individuals that had resided on this property in various trailers and questionable places. But the law would view them as a tenant, and the common word thrown around is a squatter. legally, if you've ever had an invitation to live somewhere or a prior lease agreement, whether it be a handshake or written on a napkin, you're validly still a tenant in the eyes of California law. So, uh, trying to explain to the client that these people have rights to live there still, even though the property had changed hands through a death, and then explaining to 4 or 5 less than sophisticated individuals that resided on the property that you need to move. The property is being sold, and likewise, it's time to move on. Um, we needed to go through the system to explain that to them, and they still didn't move out in time. So it's it's just a long process, unfortunately, for this particular client. It drug on for a couple extra longer months just because of the behavior of the tenants. We could not predict them and force them off the property. We just had to wait law to allow us to legally evict.
Yeah, and in that case, there were multiple structures, and that's where our process server comes in again sometimes, and we have to label each structure and identify them at the outset of the case, and then have the process server go out and post labels like numbers. So if there are 4 structures, we have to number 4 structures, and then we have to make sure if the sheriff goes out there that those structures are properly identified, or else the sheriff can't do their job. So those are really fun. So Jim, anything else that you'd want to share?
In all reality, each case or each tenancy is a little different than the other. There's no cookie cutter solution to it. It's really more a matter of understanding it's going to be a game of patience and your willingness to endure the actual legal process if it does have to go that route. I've had some clients that have only evicted one tenant in 30 years, and I have some that seem to be evicting a client or a tenant every few months. So there's definitely a number game. There's a screening process that probably can be improved in any landlord's process just to ensure your tenants are at least a little bit more likely than not to abide by the lease and pay on time and leave when asked. But it's unfortunately it's a numbers game. I feel like if you're a landlord long enough, you will be consulting an attorney for an eviction, and hopefully you don't have to file a lawsuit. But sometimes that's the leverage you do need, unfortunately, for the actual tenant to understand the process is moving forward.
Yeah. So if you don't want to have to hire us, make sure you do a really good job of screening the tenants at the outset, and make sure that your lease is in compliance. And that way, you'll avoid a lot of the problems that we have to deal with. Thank you so much, Jim and Lisa. Lisa had to run because she is super busy today. Jim, I know you're really busy today too. So thank you very much for helping me out today. I'm going to move on to some of the questions that have been posted in the chat. And if you guys do need an eviction, now you know you can put a face with a name. You've met Jim and Lisa, and they won't just be a voice on the phone.
Thank you.
Right. So let me unspotlight you here. There you go. Thanks, Jess. And Jess is always on our webinars. Jess is our intake specialist. She's your first point of contact if you're wondering how we, take on new clients and screen potential clients. And then Jess also does marketing, so she's always with me for these webinars. All right, so we've got some questions posted here in the chat already. Can we comment on short-term rentals like pad split, co-living, nurse executive housing? Do you use the same California rental agreements? Also, some management companies recommend no deposits and just getting rental insurance. So let me break that down a little bit. I'm happy to go over a few different scenarios. I think by pad split, maybe you'll need to clarify for me, is that like a roommate situation? Okay, I see you there. So if you nod, it's a roommate situation. Okay, so roommates are actually something that is one of the easiest situations for us to handle, because roommate situations are, for the most part, exempt from all of the tenant protection regulations. So if you have a roommate and your lease is not in compliance with other laws, with tenant protection laws, that's okay, because most of those tenant protection laws just do not apply automatically. So there are lots of exemptions to the tenant protection laws. Some of them are automatic, and some of them require you to claim the exemption. So a roommate is an automatic exemption that you don't have to have a written notice to the tenant to claim the exemption. For short-term rentals, your question on short-term rentals, it depends on where you are, because, for instance, in the city of San Diego, they have different licenses available for short-term rentals. And even if you are just renting out rooms, you may still need a short-term rental license. So there are more licenses available for the situations where people are renting out their own home, and there are some time limitations for those. The best place to get that information, if you're talking about the city of San Diego, is from the city's website. They have some very, very good information on there that you can just look up and see which type of license is appropriate for you. So I'd be happy to walk you through that. Probably not today on the webinar, but if you want to go, if you find that information and you have some follow-up questions, I'd be happy to talk to you about it. The nurse executive housing is generally not a short-term rental because it's usually more than 30 days. So 30 days or less can qualify as a short-term rental. By definition, it's 30 days or less for is short-term. But anything more than 30 days is a regular tenancy. If you focus on the city of San Diego, they were very specific with their tenant protection law that they have an exemption for leases that are 3 months or less. So if the tenancy is for 3 months or less, then you do not have to comply with the San Diego tenant protection law. And you also would not have to comply with the California tenant protection law, which, the tenant has to be there more than 12 months before the California Tenant Protection Act attaches to that tenancy. So depending on how long the executive housing arrangements are lasting, you may or may not be exempt from tenant protection laws. But they are generally considered tenants. So if they refuse to leave when you need them to, you may still have to go through the eviction process with them. With the short-term rentals less than 30 days or less, there is a different procedure that you can go through to remove people. So you remove them as though they were in a hotel. The sheriff, the police authority will come and help you under different circumstances if you can show that this was a 30 days or less. And there's another summary procedure that if the sheriff needs you to have some documentation to remove that person, you can do a process that's a lot like a restraining order, where you go into court and get a same-day order from the court. So those are interesting. We don't do too many of those, but it is available if needed. Do you use the same California rental agreements for short-term versus long-term? No, I would not use. So what we use in our office is the California Association of Realtors form. I would not use that for a short-term rental. That's not to say that you couldn't, but it's written for a long-term rental. So you'd have to make some alterations to it. You'd want an addendum that's pretty thorough. If you look at some of the Airbnb and VRBO websites or advice that you can find online, they have suggestions. We have drafted those leases with the suggested additions for short-term rentals. As far as management companies and security deposits and rental insurance, those are kind of broad things. So I always recommend taking the security deposit if you are having a tenant, if you are renting the property, there are limitations to security deposits now, so you really very limited in how much you can keep. So it's 1 month is the rule, and then if you qualify under the exception, you may be able to accept 2 months. But it's still important to have it, because more often than not, when the tenant decides to move out, I guess I shouldn't say more often than not, but often when the tenant decides to move out, or when the tenant receives a 30 or a 60-day notice to terminate their tenancy, they will stop paying the rent. And if you don't owe them relocation assistance, then you might use the security deposit to compensate for the non-payment of rent. Okay. Rental insurance, it depends on what it covers. So renter's insurance covers certain things. Homeowner's insurance, a landlord policy covers certain things. And so it just depends on what kind of damages you're talking about and what the insurance policy covers. So if you want to be more specific, maybe ask a follow-up question and I'll see it down below. All right, so the next question, the question is that the requester is in escrow. So you're in escrow on a 3-unit property, and there are 2 vacant units. The last unit is tenant occupied. They've been there for more than a year, 14 months, and they're month to month. Properties in San Diego. Do you mean city of San Diego? Okay. You need to remodel all the units and would like to know about lawfully getting that last tenant out. Other than cosmetic upgrades, the biggest thing this unit needs is egress windows in the bedrooms. Okay. And is this a reason to get them out? What would that look like? So in the city of San Diego and in the state of California, actually, the laws are very similar. They are written differently, but the rule is similar. When you are using the substantial remodel as a reason to remove a tenant, you first have to have your scope of work and obtain permits for the work. So things like replacing windows. We've had an interesting case. This was in Riverside County, I believe, but the issue was that part of the remodel involved windows. And the issue is that when you're replacing windows, it does not necessarily require the tenant to be out of the property. And I believe in the city of San Diego, it has to be for more than 30 days. So when you are trying to make sure that the unit becomes vacant, the substantial remodel doesn't always work. Another aspect of using substantial remodel to get the tenant out is that you then have to offer them to re-rent it to them once the remodel is complete. So if the remodel is short, then it may not qualify. If you don't want this tenant back, or you want to find some reason why you could increase the rent, you may not be able to do it the way that you want. So this might not be the best way to do it. And in that case, I might suggest a buyout agreement. In the city of San Diego, there are also special rules for buyout agreements. You have to give them a buyout disclosure, and then that has specific language, and then you have to have specific language in the buyout agreement. So if you want a little more detail, or you have some follow-up questions on that, maybe we can do that in the webinar, or maybe we'd have to talk privately. Okay. Next question. The tenant's kid caused a clog in the toilet and caused overflow damage on the wood floor in the hallway. You had to book an Airbnb for them, fix the clog, and have drying company to dry. They're scheduled to move out in June. The tenants are Section 8. Can you take back the house to repair? Do you have to continue booking Airbnb for them and pay for it? So There are a few issues here. So one thing is that you said the tenant caused the damage. When a tenant causes the damage, that is usually a breach of contract by the tenant that they may be liable for the damage that they caused. It doesn't necessarily cause the premises to become uninhabitable, so it's not a reason to terminate the tenancy, but they may be responsible for paying you back for the repairs that they caused you to do. Fixing the clog, fixing the floors, might not be enough to need them out for 30 days or more. So you'll probably have to let them back in, but we have to look at the whole situation. They're moving out in June, and Section 8, can you take back the house to repair? So my answer to that direct question is can you take back the house? I would say probably not. You probably need to repair it and let them come back in and then deal with whatever fallout from the expense of the repair you need. The other thing I would suggest is making sure that your tenants have renter's insurance. Renter's insurance will usually pay for a certain amount of relocation. And if you have it in your lease, it's important that once they move in, you also request that they provide you with the copy and confirm that you are named as an additionally insured on the policy. You want a copy of the policy so that, if you have to engage it, you might be able to contact the insurance company directly and not have to wait for the tenants to do it for you. If the premises are uninhabitable, the landlord cannot charge rent, and the landlord is also responsible for the tenant's out-of-pocket expense. So if the issue with the toilet and the gray water or black water, flooding the property, I would say that qualifies as uninhabitable. The landlord becomes liable. And in this case, there's a give and take here because the landlord didn't cause the damage, but the landlord is responsible to fix the damage. And then the fallout is, how do you obtain compensation from the tenant later on? So, there might be different ways of interpreting this specific scenario, and I don't know all the details, but that's my take on it. Okay, so the next one is for Jim. It says, "Hi, Jim, you helped us with the tenant eviction at La Costa Carlsbad, and thank you for helping. You were so efficient." I'm pretty sure he's here. Jim, you want to?
Well, thank you. I don't know who might have said that. I unfortunately have all these blend together after so many times talking to people that sounds like it was a success at least. We didn't have to sue someone, so that's always a victory.
You're identified as iPhone, and you're welcome to remain anonymous. But if you want to tell us who you are, you're also welcome to unmute and let us know. All right.
Jasmine. Hi. Hi, Jim.
Say your name again?
Stefania. Yeah.
Oh, hi.
Hi, how are you?
Good. Thank you
Talked
for
with
coming to the
Stefania
webinar.
recently. Yeah. It was great working with you guys. You were great. Thank you.
Thank you
Thank you.
so
I
much.
appreciate it.
Yeah.
All right. So next question on a 3-bedroom rental in San Diego. If 6 people apply to live there, is it lawful to say no for that reason? If 6 people apply to live there, you mean like one application for 6 people? Ah, okay. That's an interesting one. Is it okay to say no because there are 6 people who want to live there? Or can you charge them more for the number of people beyond 1 per bedroom? Few issues here. One, you need to know zoning because I believe there's a limitation on the number of adults that can live in a single family residence, and it has something to do with the amount of parking available. It's been a while since I looked that one up. But so that may be one reason why you have to say no to that applicant, because it might be illegal. However, on the other side is you cannot discriminate against family size. So a large family, if it's, a mom and dad and 4 children, saying no under those circumstances could be considered discrimination. So on a case-by-case basis, you really have to look at the reason you're saying no. And when we have an eviction against tenants who raise discrimination or retaliation as a defense, what we need to make sure that we have is one really solid reason that this was not discriminatory or that this was not retaliatory. So in a case like this, if it's 6 adults and you know that zoning does not allow 6 adults to live in a single family residence in this area, then that may be one good legal reason to refuse. But on the other hand, if you don't have any other reason than the size of the family, that could be problematic. Okay, so next question. What are the most common lease defects? The most common lease defects right now are leases that fail to claim the exemptions from tenant protection laws, or leases that are for properties that are not exempt or cannot be exempt from tenant protection laws, but do not have the proper notices to the tenants. So, depending on the location of the property, the lease must have notice to the tenant. I was just talking a little bit before about, roommate situations. There are some situations where this compliance issue is not an issue, but most of the landlords that come in do require compliance with tenant protection laws, and they have not complied. And so, as Jim was saying, this often requires us to go through a process that takes 30, 60, or 90 days to bring all of the units into compliance before we can even take a step toward terminating the tenancy. The other defect that we see is when the landlord has issued their own notices, and then they come in and they say, okay, I'm ready for my eviction. And we look at the notice and they just aren't right. They're not in compliance with the law. It may be the notice, it may be the lease, it may be both, but we just have to look at the whole situation, and usually we have to fix something. What are the Imperial Beach tenant law changes? Oh my goodness. You know what? Jim brought this up and I blame him because I don't have that in front of me, but Imperial Beach recently passed their own tenant protection law that looks quite a bit like the one that you see in the city of San Diego and the city of Chula Vista. The details of it, I like to send out freebies after the webinar, so I think that would be a good freebie. I can send you that one. Where's my pen? I had a pen here. Okay. So we'll send out the Imperial Beach tenant protection law, and a great resource for finding those. Sorry, I'm blurry now. Okay. A great resource for finding those laws would be to go to the city website. So the City of Imperial Beach website and you just search on that website tenant or landlord, and it's usually the first thing that'll come up. Okay. What are some lease defects due to recent changes in the law that are not on people's radar? In the city of San Diego, if you want to use the so if you are not exempt from the tenant protection in the city of San Diego, and you want to use the reason to terminate the tenancy that the landlord or their immediate family member is moving in, you have to have that in your lease at the outset. So when you enter into the lease with the tenant, your lease has to say that if the landlord or their immediate family member wants to use the property, that you're allowed to use that to terminate the tenancy. So there are many form leases that have that language in them, but there are many that do not. So I have a City of San Diego addendum that I like to use when we're drafting a lease for a property in the city. Other lease defects due to recent changes in the law. So those notices that I was talking about are also required to be in your lease at the outset. As of January 1st, 2024, you had to have the notice of exemption or the notice of non-exemption and the City of San Diego Tenant Protection Guide incorporated into your lease. It's the California Tenant Protection Act also requires the notice of exemption or non-exemption to be part of your lease at the outset. We often just fix it because we have no choice. I mean, the best we can do if someone does not include that in their original lease is that we change the terms of the tenancy. But the way the law is written, it requires these things to be part of your lease at the outset. What happens if you don't go through an eviction lawyer and file directly with the court? What are the measures we need to consider? You are able to file your own eviction with the court, and people often do. You see a lot of people who are impropria persona, which is Latin for representing themselves. And on the landlord side, you can also go to various clinics. And on the tenant side, you can go to various clinics where they'll help you for free. The challenge is filling out the forms correctly, names matching. When you have, Lisa was here talking to you before. She's our guru because she knows all of the things. She's worked with me since 2012, and we've been doing evictions the whole time. She has seen just about every reason why a court clerk will reject a document. And there are many. We used to have a notebook called the Bible. We called it our eviction Bible because it was a list of every single rejected document and the reason for the rejection. And so filling out those forms, getting the names to match, making sure the procedure is followed correctly, and getting all the way through the process is the hardest part. Because yes, it's challenging to issue a compliant notice and to file a compliant lawsuit, and to then, you file it, you get it served, you wait a certain number of days, and then you'll either get an answer or a default. If a tenant answers, you have to request to set the case for trial. The court doesn't do it automatically. So we get calls from landlords who don't understand why the court won't hear their case. They don't know that there's a form they have to file with the court to set the case for trial. And if all of that sounds complicated enough, the most complicated part of an eviction is entering the judgment after you've completed the trial. So you either go to trial or you take a default. Then you have to enter judgment paperwork. And the judgment paperwork is the trickiest part. We still sometimes have long discussions about how to fill out the judgment paperwork. And if you submit it and it's not right, it takes weeks and months for the clerk to reject it. And then you have to refile it and get back in line. So it can seriously delay your eviction if you don't get it right the first time. And if that happens repeatedly throughout the process, then it really slows things down. I heard that the court is going to hire more people, or that in the last month they have hired more people. And so we're hopeful that that means that things will start moving a little faster. But it just takes time. Okay, take us through the process, steps, and price. So I think you've heard a lot of the process, especially just now, as I said, here are the steps and here's where things get stuck through the process. We meet with the client, we review the lease, we issue the notices, or, the notices may be to bring them into compliance, or the notices may be to terminate the tenancy, or both. Then once the notices expire, we can file the lawsuit. The lawsuit gets served. The tenants either respond or they don't. We submit paperwork according to whether they respond or they didn't respond. that splits the case. Either it goes to trial or it goes to default judgment. Cases that go to trial, they get set pretty quickly within 21 days of our request to set the case for trial. So that's when Jim jumps in and he has to prepare really fast and get all the witnesses coordinated really fast. We have the trial, and after trial, the judgments, we file the judgment paperwork, and that's usually the quickest way to get your judgment, is to go to trial and then do the judgment paperwork. The other part of it is that when it's a default judgment and we file the default paperwork, that takes weeks and months to get those default judgments. The tenant can stay there the whole time until the sheriff comes out and removes them. But how do you get the sheriff? Well, you have to have your your judgment paperwork. So the judgment paperwork includes a writ. The writ, once you have it, you take it to the sheriff with all of their instructions. They have their own procedure. We file a bunch of forms with them and then pay them $180. And they, in due course, they have up to 6 months to execute a writ. So it usually takes them, 4 or 5 weeks, and they go out to the property and they do their lockout procedure. Pricing depends on what happens in the process. So average evictions cost about, most of them do not go to trial. Most of them go to default judgment and cost about $2,500 or $3,000. But cases that go to trial cost $10,000, $20,000. It just depends on how far it goes. The tenants can request a jury, and those are expensive trials generally. Some tenants file bankruptcy, and that can also cause us to have to go back to court multiple times as the case gets continued during the bankruptcy process. All right. How much coverage do you suggest to ask the tenant to get for renter's insurance? I know we ask that they put the landlord's name on coverage, but overall, what type of scenarios can the landlord use this insurance? I talked to an insurance representative from my networking group, and she advised that the amount of coverage should be full coverage for the property in case the tenant burns it down. I was advised by this insurance agent that there are insurers out there that if they find out that the tenant caused the fire, then your homeowner's insurance might not cover you. I talked to another insurance representative that said that your homeowner's insurance would still cover you as long as you have a landlord policy. And I think that that's correct. But I need to just tell you that I got a difference of opinion about how much coverage would you suggest, because one opinion is that the tenant's coverage should cover their displacement and their own personal property. But other opinion is that their coverage should be enough to cover all of the damage that they might cause to the property, which would be full coverage for the property. So the advice that I would give is to talk to your insurance agent and ask them that question, because I'm not an insurance agent, and it probably varies depending on who your insurer is and what kind of policy you have. Make sure that if you're a landlord, you have a landlord's policy. Otherwise, it's possible you might not have coverage. And if the property becomes vacant for an extended period of time, make sure that you have a policy that you have to notify your insurer and make sure that you have a policy that covers the vacant property. Okay, are pet deposits still allowed? They are, but the security deposit includes the pet deposit. So the limitation on how much you can charge as a security deposit is all inclusive. So if you're charging a security deposit and a pet deposit separately, it still can it cannot exceed the limitation of 1 month of rent unless you qualify to charge 2 months of rent. And military, you can never charge an active military service member more than 1 month of rent equivalent for security deposit. All right. Adjusters are calling to rent for fire victims. Are we allowed to ask the details of why they are out of housing? Insurance companies pay the rent. What do we need to be cautious of here? So one thing to be cautious of is the anti-gouging statutes. It's been a while since I looked it up because I think all of the price gouging things have probably expired, but I'm not sure. Maybe in LA they're still in effect. Whenever there's a natural disaster, then there are price gouging statutes that go into effect that prevent you from increasing the rent more than 10%. So you can't gouge on the rent because there is a demand due to a disaster. Are you allowed to ask the details of why they are out of housing? Yes. You just can't ask questions that would trigger concern about discrimination. So that's a whole discussion that is specific to the facts and the reasons why, you know. So when I'm counseling a client, these discussions are very detailed about, you know, why are you asking this? Let's phrase it differently so that we avoid any potential misinterpretation of this language. One example is that the landlord wanted to rent the property out as a high-end rental. They wanted to charge a high amount of rent, and they wanted to make sure that the tenant had enough income. But we're very sensitive about asking tenants about their source of income. So the language that I recommended is, you know, they wanted to say that the tenant must have income of at least X dollars. And I suggested the tenant must have income of at least X dollars or other equivalent, something like that. So make sure that you're inclusive of other kinds of payments. Can Section 8 tenants be required to carry renter's insurance? I've heard no. I've heard that you cannot require that with a Section 8 tenant, but I'm not entirely sure why. I think that it has something to do with what Section 8 tenants can be required to pay. So I think they can be required to pay utilities, but in the agreement that you would have with the Section 8 authority, there may be some limitations on what you're allowed to require them to pay in additional costs, because Section 8 is based on their income. And so you'd have a discussion with the Section 8 provider about that. All right. So Greg, you were clarifying that in this case, the people in that property are roommates, not family. And so marital status is also a potential source of discrimination. Also gender, you know, those sorts of things. So there's a lot of landmines in that. So I'd just be careful. Look up the zoning though, and I may be able to point you in the right direction for that. Where can you check? You're reading my mind. Yeah, I have to look it up. It's buried somewhere in my files. If you offer move-in incentive of the 13th month of rent-free with a new 12-month lease signed, are you using the face amount of the lease or the average paid over the 13-month term to determine how much we can base the rent increase? It's written. So the rent increase, you cannot raise it more than, if you're subject to the rent cap, which in San Diego is 8.6 for this year, you cannot raise it a total of more than 8.6% in any 12-month rolling period. So from today back 12 months, we take what they paid 12 months ago and what they're paying today, and it's the difference between today and 12 months ago. You can increase the rent twice in a 12-month period, but those two increases cannot equal more than the rent cap. If you are giving them the 13th month for free, it's still, I think we would still, I'd have to think about it, but as I think about it right now, you would still be looking at what their new rent would be. So it's not an average. It's, okay, here's the rent that you have to pay now, and here's the rent that you were paying 12 months ago. That's what I would say. Maybe we could debate that, but I think that's how it would be interpreted. Oh, thank you, Jim. Jim gave me the Imperial Beach Municipal Code here. And let me make sure I know who asked that question, because I will email this to you. I have your email address. Sorry, bear with me one sec. See. All right, I will find you. I got your name and your email, and I will email that Imperial Beach ordinance to you. All right. So we're running out of time. I talk too much. I'm sorry. Jasmine and Stefania, check in with me later, because you've got some follow-up stuff here. So if you hand delivered and mailed a notice to vacate upon expiration of the lease, the owner, because the owner will be doing various upgrades with no permits required, does the owner have any financial obligation after termination of the lease to the tenant? So that depends on whether the lease is exempt from tenant protection law, because if you are not exempt, then you can't just terminate a tenancy because the lease expires. But if it is exempt and you're terminating it upon expiration of the lease, then you've given a 30 or a 60-day notice in advance, and assuming that relocation assistance was not required, then there would be the financial obligation of the security deposit. So I think I might not be fully understanding your question, but in the interest of time, I'm going to keep moving, and you feel free to email me. Let's see, where can you find the tenant protection for Lemon Grove? The website appears to refer to the city of San Diego. Is Lemon Grove part of the city of San Diego? I think it's its own area. So I don't know, because I wasn't aware that Lemon Grove had its own tenant protection ordinance. If it does, I'm going to look it up, and I will also be sending you guys that one as a freebie. Does anybody know? Did Lemon Grove pass its own? Or does anybody know whether Lemon Grove is part of the city of San Diego? Let me see. I'm going to look it up. Is Lemon Grove? Pretty sure it's its own city. It is a city in San Diego County, so it would have its own tenant protection. And then nothing is coming up immediately, but I will look into that. And if I find it, I will let you know. Sorry. I like to think I know these things, but I don't know everything. Okay, so we have a bunch more questions. I love that you guys brought your questions. I had like a whole thing prepared because I was worried that you wouldn't have enough questions for me. But I'm gonna also download the rest of the questions and make sure to answer those in the freebies as well. Let me see if there are any easier ones. I have a client that needs a short sale. Oh my goodness, they're coming back. I'm getting so many calls about mortgage hardship, questions regarding mortgages and loan modifications. And I've heard short sale probably twice in the last couple of months, which is just very unusual. So client needs a short sale. 1-year lease ends at the end of June. Can you give them a 60-day notice to vacate at the end of the lease? You can give them a 60-day notice to vacate 60 days prior to the end of the lease. However, based on your question, I don't know if they're exempt from tenant protection. So if you have to comply with the tenant protection laws, the lease ending is not a just cause to terminate the tenancy. You have to offer them a new lease, and if they reject the new lease under similar terms, then you can use that as a reason to terminate the tenancy. So I don't know if you can do that, but I would suggest maybe negotiating a buyout. Okay, so then as far as the owner moving into the property after the upgrades are completed, if it's in the city of San Diego, make sure that that's in the lease, but that could be a just cause to have the owner move in. And you want the city of San Diego lease addendum. I will send that out as well. Okay. If you use that, then your leases will always have that language in them. Lisa confirmed that the court said they pulled more people in to work on clerk judgments for possession only, which will cut down on the time it's taking to get those judgments. The court judgments for money may slow down more. So it takes longer. If we're getting a judgment for possession only, we often talk to the client about, if possession is the main thing because you don't think the tenants are going to be able to pay a judgment, then it makes more sense for us to fill out our paperwork for possession only, because the court will process those faster. If you want possession and a money judgment, those judgments go through more slowly, and the judgment might not be worth anything. You can also get a possession only judgment and then amend it later to include the past due rent. All right, guys, I have got to cut us off here, but thank you so much.